Hey ho again. Let me first apologise for the sound of the rain. That's part of the reason that I'm putting music behind my audio. Both are probably equally as soothing, depending on the ears that are listening. Anyway, let's get on with it. As I noted in the description of my previous video, Chris McDonough was a party to the summary judgments and subsequent appeals, where I suggested he is probably the best person to speak on those topics. Likewise, Mr. and Mrs. Crowe were privy to nearly everything that went on from start to end and then some. So in this video we will hear from them in their own words what it felt like to be victimised by an institution like the state. Everything we know about Summer Stephen's role in the Stephanie Crowe murder case. Interim DA Summer Stephen has defended her role in prosecuting 3 teen boys for the murder of 12-year-old Stephanie Crowe and suggested major decisions were made before she joined the prosecution. But interviews with key players, media reports and court records shed a light on how important she was to the case and what went wrong. Summer Stephen could not be in a better position to win next year's race for District Attorney. This is written in 2017, by the way. First, she is District Attorney. County supervisors appointed her in June when her mentor, Bonnie Germanis, resigned. In her campaign to win the position outright in 2018, Stephens received endorsements from powerful Republicans and Democrats. She has raised money and her profile in the media after a year of careful cultivation. But one part of her biography looms large: the 1988 murder of 12-year-old Stephanie Crowe, a mystery that took down another former DA when Germanis used it against him to win his job. More specifically, hanging overhead is the prosecution of 14-year-old Michael Crowe and his 2 friends, which Stephanie led before she and her office had to drop the case in disgrace. Now, the parents of Crowe have emerged as Stephen's most passionate and compelling detractors in a bid to win a full term as District Attorney. They submitted to the County Board of Supervisors a scorching 22-page recital of ways Stephen allegedly mishandled the prosecution of their son, and they allege she's the reason nobody stands convicted of the crime. I do have this document.
And they asked me who would want to hurt her, and I said, there's no one. I wouldn't know anyone that was. She's 12 years old. They pretty much herded us into the living room. They got everyone and had us sitting on the couch. Wouldn't let us really, move or nothing. I asked them not to separate the kids. I said, to at least let them be with either Cheryl or Cheryl's mom, and they promised me that they would not separate the kids from us. Each of us were separated in our own little rooms, and with nothing but just another policeman or cop sitting there staring at us the whole time. And we were there all day. They informed me that they were going to take pictures of us and take our clothes for evidence. And I wasn't too happy about that because they said that they were going to photograph us naked. The cop came back in and said that they're taking the kids away from us. And they're going to they're taking them and putting them in protective custody. Well, at that point, I'd had enough, and I threw a fit.
The kids were crying, and they were upset, and I just said, well, it's going to be okay. These are the good guys. They're here to help us, like we've taught them their whole lives. And I just hugged them and told them we'd get them as soon as we could. And then I had to leave.
They took Michael and his little sister Shannon away from the family at the time the murder was discovered and put them in the Polinsky Center for Children, which is basically a receiving facility for abused children.
They kept saying to each one of us, it's not going to be another John Benet Ramsey, it's not going to be another O.J. Simpson case.
They told us that day that we weren't under arrest and that we can leave at any time. So after they'd taken the kids away, I said, well, then let's go, because I'm through with this. This is ridiculous. So we walked downstairs to the police department, and the second we touched the glass doors to exit, they were locked. But the second we did that, there was cops coming out of the woodwork and with their guns drawn on us. And the one detective, Detective Risley, standing there with his gun pointed at my chest, yelling at us, "Get back upstairs." And I'm thinking, you know, what is this guy? He's nuts. So we complied with him and went back upstairs.
Michael, first of all, here's this poor kid who's emotionally distraught because his sister was murdered. He doesn't even have the adults in his life to comfort him. Nobody endeavored to give him any therapy or anything.
They just kept grilling and grilling and grilling. And to think that we were at home, not even knowing he was near the police station. If we would have known, we would have been there.
They made an arrest in the case. And I said, "Who is it?" And they said, "We've arrested your son." They took him off camera. He wanted to see us. And what they told him was that your parents, know that you murdered their daughter and they don't want to have nothing to do with you no more. They hate you. We're the only ones that you have now. And they brought him back on camera and his demeanor changed. Because now Michael's trying to please the only people he thinks he has left. 12:30 at night, we got a call from the police station. And it was Detective Sweeney saying that they made an arrest in the case. They arrested the murderer of our daughter. And I said, who was it? Who is it? And they said, "We've arrested your son."
We thought he'd done it. I mean, because at that point, because when a police officer tells you that someone did something, you think that they did it. I mean, we had trust in police up until this point.
The first thing I asked Michael when he got on the phone was, did you have anything to do with this? Did you murder Stephanie? And he said, "I don't know, Dad. They keep telling me I did it, but I don't know." Why would Michael murder his sister? I mean, they had never fought. There was never any, what the police called intense sibling rivalry. The night before Michael had helped her with her homework, they were lying on the floor sharing a pillow watching TV together. It just didn't make sense to me.
Welcome to the Rick Roberts Show.
On the same day the case is dismissed, Detective Chris McDonough calls into this radio show to defend his role in the interrogation process.
I did not wake up at 2 o'clock in the morning and sit down and say, you know what, today's the day I'm going to plant and frame Joshua Treadway for murder.
Well, I don't think that
ridiculous.
anybody... Detective McDonough, I don't think anybody is saying that this is born of hostility rather than stupidity.
If I may finish, secondarily, on top of that, videotape it at the same time. It's ridiculous. I am in a job to bring justice to that family, but I'm also in a job to bring justice to Mr. Tuitt if, in fact, he is not the perpetrator.
If I ever see him walking the streets, God forbid, I'll make sure justice is served.
For the average person, I mean, how do you get a prosecutor to prosecute the man who murdered your daughter? What is it going to take? I mean, her blood screams for justice, and no one's listening.
Moments ago, a press conference just wrapped up featuring the parents of Stephanie Crowe.
They are weighing in on the district attorney's race against interim DA Summer Stephan. This is ahead of Tuesday's primary.
It's been 20 years, but it doesn't go away. My daughter was murdered in 1998. That being said, that event was only compounded by a prosecutor, Summer Stephan, lying and making our lives even worse. My daughter Stephanie's in a grave. She was murdered. Her killer got away with it. I think it would have been a lot different if Summer Stephan had not been assigned to the case. She spent a page and a half in her application of explaining how her handling of my daughter's case showed how compassionate, ethical, and competent she was. In truth, she was mean, unethical, and incompetent.
I have his confessions to the 3 persons in juvenile hall, and many other elements that will come in the trial. I have plenty against the other 2. I have the circumstantial evidence that this was an inside job. I have the murder weapon. I have the fingerprints of the accomplice on the murder weapon.
Prosecutor Summer Steffen says new DNA evidence found on transient Richard Tewitt's sweatshirt conflicts with confessions the boys made to Escondido police. And she says everything needs to be looked at again.
Everything means evidence that is supportive of the guilt of the charged defendants and evidence that might be supportive the other way. And that's important to be fair about that investigation.
Do you believe the boys still did it?
What I do know is that there is a significant body of evidence against these defendants.
So we shall read it. It was written by Stephen and Cheryl Crow on June the 12th, 2017. Dear Honourable Supervisors, statements made in Summer Steffen's application for appointment of the election of office of the District Attorney prompted me to write. In her application, Steffen cites the Stephanie Crow case as one in which she followed her conscience and did the right thing. She cites facts to support her claim. Her facts are false and her message is untrue. Steffen's representations are disturbing because they were made under oath. She swore that all information provided on this form by me, including all attachments, is true and correct. Her signature appears beneath the words. I certify under penalty of perjury that the foregoing is true and correct. In part 5 of her attachment, Stephanie devotes a page and a half to the Crow case to showcase her prosecutorial virtues. Her main points are 1. She inherited the case from another prosecutor. 2. Which was extremely unfair because critical decisions had already been made. 3. She followed her conscience and did the right and ethical thing. And 4. Never committed prosecutorial misconduct. These main points are all untrue. I know what Steffen did in the Stephanie Crow case. Stephanie was my daughter. Steffen is using my dead daughter to promote her political ambitions through falsehood and misrepresentation. I am not going to let her get away with it. The murder of Stephanie Crow. My 12-year-old daughter Stephanie was stabbed to death in a bedroom on January 20, 1998, between 10 and 12 p.m. by a mentally unstable, drug-addicted transient named Richard Tewitt, who was roaming our neighbourhood that night threatening to kill a girl named Tracy. 3 days after Stephanie's murder, Escondido police arrested my 14-year-old son Michael. 2 additional arrests followed, of Joshua Treadway and Aaron Hauser. Police said they all conspired to murder Stephanie. Michael and the 2 boys were innocent. 2 courts, one federal, the other state, have so found. The first paragraph of Crow versus San Diego, decided by the 9th Circuit Court of Appeals, begins. This civil rights case arose from the investigation and prosecution of innocent teenagers for a crime they did not commit. Michael Crow, Aaron Hauser, and Joshua Treadway were wrongfully accused of the murders of Michael's 12-year-old sister, Stephanie Crow. After hours of grueling, psychologically abusive interrogation, during which the boys were isolated from their families and had no access to lawyers, the boys were indicted on murder charges and pre-trial proceedings commenced. 2 years after this decision, on May 22nd, 2012, Kenneth So, Judge of the Superior Court of the State of California and for the County of San Diego, found Michael and the other boys factually innocent. A finding of factual innocence is extremely rare because it essentially requires the person requesting the relief to prove his own innocence beyond a reasonable doubt. Stefan was not late to the case. Stefan claims she was late to the case. She swears the facts are that another prosecutor in an entirely different division from mine brought murder charges against 3 men and presented the case to a grand jury and obtained an indictment. 6 months later, when the case was facing significant issues, I was asked by DA Paul Pfingst to step in. Stefan, along with her political sponsor Germanus, have launched a public relations campaign to convince the public of this fact. On June the 3rd, 2017, the Union Tribune reported that Germanus said, but because Stefan was not the original prosecutor, inheriting a case that was already a mess, it's unfair to blame her, Germanus said. Stefan and Germanus both conveyed the message that Stefan got involved after the teens had been charged and the grand jury indicted them. Stefan's sworn application, as well as the public representations of Stefan and Germanus, are untrue. Criminal prosecutions are initiated by indictment. Indictment is the first step in the criminal judicial process. Grand jury proceedings are secret. The prosecutor calls witnesses who are sworn and testify under oath. The prosecutor presents the evidence to persuade the grand jury to return a true bill. A true bill charges a defendant with a specific crime. After a true bill is returned, the defendant is taken before a judge, arraigned, informed of the charges, and asked if he pleads guilty or not guilty. In serious cases, it is not uncommon for the DA's office to assign 2 prosecutors. This is what happened in the Stephanie Crow case. On the very first day of grand jury proceedings, 2 prosecutors appeared and introduced themselves as co-prosecutors to the grand jurors. Their names were Gary Huber and Summer Stefan. The illustration of the grand jury transcript proves that to be the case. The fact that Stefan is not telling the truth under oath and that she and her political sponsor Germanus are peddling a false story to the public is significant. An individual who makes a false statement of material fact on a job application may not be a suitable employee, especially for a job which requires ethics, honesty, and straight talk. Other untrue statements made under oath. Stefan's affidavit is not the first time she told her false story under oath. In 2002, our lawyer deposed her in Crow versus County of San Diego, a case brought in federal court against multiple defendants for violating our civil rights. The Stefan who appeared at her deposition was a far cry from the Stefan who was cruel towards me and my husband during the case. For example, she knew that Steve and I wanted to watch all of the proceedings. After all, our daughter had been murdered and our son was accused of killing her. At one point, Stefan subpoenaed us as an act of spite. She did not intend to call us as a witness. She did not call us as witnesses. She subpoenaed us so she could get us kicked out of the courtroom. The law says that a subpoenaed witness can be excluded from the courtroom. This reason is to avoid the possibility the testimony of the witness will be influenced by other witnesses. Either side can ask that a subpoenaed witness be excluded. Many times the lawyers don't ask. They use their authority in good faith because They are legitimately concerned that the witness's testimony might be influenced. What they do not, or at least should not do, is use this authority as a way to punish. This is exactly what Stefan did. She had no intention of calling us and did not call us, but she subpoenaed us and got us kicked out of the courtroom. I went to her office and confronted her. I said words to the effect, "You are always talking about how much you care about victims and their families. We are victims. Our daughter was murdered. This is how you look out for us? By kicking us out of the courtroom? We are victims. Why are you treating us like this?" "Victims have to cooperate," she replied. "I can't help victims unless they cooperate. You are not cooperating." "What do you mean? We've done everything you've asked. We took off all of our clothes for you. You have nude pictures of us. We gave our blood. What else do you want?" "I want you to admit that Michael murdered Stephanie. Otherwise, you are not cooperating." As an entirely different Stefan appeared at her deposition. She came with her mother. She asked our lawyer if her mother could sit next to her during the deposition. Our lawyer did not have to say yes. Only parties have a right to be present at a deposition. Our lawyer granted Stefan's request. Her mother sat at her side and comforted her between breaks throughout the deposition. At the deposition, Stephanie told the same story she is telling now. "I wasn't there from the beginning. I wasn't familiar with everything, and I didn't think it was fair to me to pick up somebody else's case." Stefan's concealment of exculpatory evidence. In addition to portraying herself as a victim, Stefan cast herself as a righteous, ethical hero, especially in connection with the Crowe case. In the thousands of cases I have handled, I have never been found to have committed prosecutorial misconduct. This is a rare thing for a prosecutor, trying and handling so many cases over so many years. Stefan has a way of slicing words carefully to convey an impression which bears little resemblance to the truth. She always leaves herself a way out. For example, she will probably say that even though Stefan and Hoover appeared as co-prosecutors at the grand jury, Hoover was the first prosecutor to be assigned the case. She may have more difficulty explaining the facts are that the other prosecutor brought the murder charges and presented the case to a grand jury and obtained an indictment. 6 months later, I was asked but Stefan has proved herself to be very nimble when dancing around the truth. Stefan's never been found to have committed prosecutorial misconduct is another example of careful wordsmithing. Although it may well be that she has never been found to have committed prosecutorial misconduct, she has actually committed prosecutorial misconduct in my daughter's case. Who else is a careful wordsmither? Oh yes, Chris McDonough, who would ask us to believe that a upholding of the conspiratorial charges against him meant that he was completely absolved of all wrongdoing, which we now know is not the case. The most serious type of prosecutorial misconduct. One of the most serious types of prosecutorial misconduct is failing to disclose exculpatory evidence to the defense. Now, I explained this to you in the previous video that this is called a Brady violation. Exculpatory evidence is evidence which has a tendency, in reason, to show that a crime was not committed or that the defendant might not have committed it. The obligation of the prosecutors to turn over exculpatory evidence to the defense was first established over half a century ago in Brady versus Maryland. The duty to disclose was based on the principle that it is the job of the prosecutor to see that justice is done. Brady was followed by a series of California Supreme Court cases interpreting the California Constitution, which broadened the prosecutorial duty to disclose. A prosecutor had to disclose exculpatory evidence even if the defence lawyer had not asked for it. The court also plugged loopholes. It held that prosecutors could not avoid knowing about exculpatory evidence by being willfully ignorant. For example, they could not tell the police not to inform them about exculpatory evidence. They could not tell police not to write a report. If there was no report, they had a duty to produce one. In the eyes of the law, if the police knew, so did the prosecutor, and the prosecutor had an affirmative duty to turn over the exculpatory information to the defence. Currently under California law, it is a felony for a prosecutor not to turn over exculpatory evidence to the defence under Section 141 of the Penal Code. Stefan's most compelling piece of evidence. From beginning to well past the end, Stefan claimed that her most compelling piece of evidence was the fact that Michael lied to police about not seeing Stephanie's body. After the charges against Michael were dismissed, Stefan went on 48 hours to defend her actions and describe the evidence against Michael. She singled out the most compelling piece of evidence. The most compelling piece of evidence was a statement he made. The brother told his family and told the police that he woke up at 4:30 in the morning and he turned on his TV light and he got out of his room and that his sister's door was closed at the time and he saw nothing amiss. The investigation showed that it is pretty much not reasonable that somebody could walk out of their room at 4:30 and not see the body there. Some context. There were 6 people in the house. Steve and I were in our bedroom, Grandma Kennedy and 10-year-old Shannon in theirs, Stephanie in hers and Michael in his. Everyone was in the bedroom before 10 p.m. We routinely closed our doors at night because we lived on a rural hillside in Escondido. There was a lot of flammable brush and trees on the hillside. The fire marshal came through and told us to close our doors at night. Stephanie was in her bedroom talking on a phone with a friend at 10 p.m. Her friend's mother looked at the clock, saw it was 10, and told them to end the conversation. Therefore, Stephanie was still alive at 10 p.m. Stomach contents proved she was dead by midnight. Michael told us and the police voluntarily and without prompting that he had gotten up at 4:30 in the morning, walked to the kitchen to get some painkillers, returned to his room and had not seen or heard anything. This, according to Stefan, was the most compelling piece of evidence. She said it proved that Michael was lying, which in turn proved he was the murderer. Stefan and Detective Sweeney said Michael was obviously lying because Stephanie was in the hallway and he would have had to have tripped over her on the way to the kitchen. I never understood this most compelling piece of evidence. If Michael had murdered Stephanie, why would he have voluntarily and without prompting tell us and the police about getting up at 4:30 a.m. and going to the kitchen? Stephanie and the police had a ready answer. Michael was afraid someone had seen him up at 4:30 a.m. when he got up and walked to the kitchen. I thought that this was absurd, but it was not unusual. Stefan and the Escondido Police Department came up with a lot of foolish ideas and theories. Stefan's most compelling piece of evidence at the 707. After Hoover and Stefan, acting together as co-prosecutors, presented evidence to the grand jury and obtained an indictment, the next big hearing was the 707 hearing. It was conducted in juvenile court before Superior Court Judge Laura Hams, a former prosecutor. The purpose of a 707 was to determine whether the defendant should be tried as an adult. The 707 hearing lasted 4 months. At the time, the longest 707 in California history. By this time, Hoover was no longer on the case. Stephan was the only prosecutor. A centerpiece at the 707 was Stephan's most compelling piece of evidence. She presented it through Detective Sweeney. Stephan carefully plotted out how she asked Sweeney questions. The result was to create a false impression. Stephan elicited testimony that Stephanie was found lying in the hallway. She elicited testimony that the hallway was 3'6" wide. She elicited testimony that Michael's door was directly opposite Stephanie's. The obvious inference was Michael would had to have seen her. Stephan and Sweeney knew better. They both knew that Stephanie was not lying in the hallway. They both knew that almost all of Stephanie's body was in her room. They both knew that the top of her head was lying on the threshold of her doorway. They both knew that her door did not open onto the hallway. They both knew that it opened out onto an alcove off the hallway. The alcove was 2.5 feet deep, the same depth as Stephanie's bedroom closet. Judge Hams was frowning while Stephan was asking Sweeney about her most compelling piece of evidence. Judge Hams was looking at the diagram Stephanie showed Sweeney drawn, her eyes alternating between it and the crime scene photograph spread out on her bench. She interrupted Stephan's questions. She told Stephan and Sweeney that it did not appear that what they were saying was accurate. She said that Stephanie's bedroom door does not open directly into the hallway. There's just a little corridor before you get to the hallway. Sweeney and Stephan changed their story. Yes, it was an alcove, but it was a tiny little alcove. It was only 12 to 18 inches deep. The truth was, Sweeney never measured the tiny little alcove, and it was not 12 to 18 inches, but 2.5 feet deep. The legal issue before Judge Hams was very narrow. She was not called upon to decide whether the boys were innocent or guilty, only whether they met the statutory criteria for being sent to adult court. She decided that they did, but in doing so, Judge Hams made a solemn statement to Stephan. She suggested that Stephan take a very close look at the case, because if she had been sitting as the trier of fact, she would have found Michael and the boys not guilty. Stephan did not heed the advice. She doubled down on her most compelling piece of evidence. Who else doubles down when they know that they're wrong? Oh yes, Chris McDonough. Stephan's undisclosed crime scene reconstruction. After the 707, but before the trial, Stephanie decided to bolster her most compelling piece of evidence by conducting a crime scene reconstruction. Stephan arranged for a reconstruction which would duplicate exactly the same conditions inside the house on the night of the murder to prove once and for all that Michael was lying when he said he did not see Stephanie's body. Stephan drove to Escondido and met with the other participants. Among them were her investigator, P.J. Hahn, and the Escondido Police Homicide Detective, Ralph Claytor. Stephan made sure that a television was placed in Michael's room and turned on because Michael said he had turned on his TV before leaving his room. Stephan believed this would have provided additional light. A female was placed where Stephanie's body was found. A series of photos were taken, the first 2 taken with a flash. The rest were taken without a flash. The 2 on the upper left were taken with a flash. The rest taken without a flash showed what Michael saw. Pitch black. Absolutely nothing. We did not learn about this until years later, after our lawyer filed our civil rights case, subpoenaed all the evidence, and took well over 100 depositions. He confronted Stephan with the evidence at her deposition. Stephan admitted that she DA investigator Hahn, Detective Claytor and others assembled at the Crow's house at night to photograph what Michael would have seen at 4:30 a.m. Stefan admitted that a female was placed in the doorway with the same lighting conditions and that photos were taken, except for the ones taken with a flashbulb. They all came out pitch black. And there's the illustrations for the crime scene reconstruction. Stefan admitted that the photos were exculpatory. She admitted that she had an obligation to furnish them to the defence. She testified that she had no memory of providing this exculpatory evidence to the defence. She testified that no report of the reconstruction was produced and given to the defence. I like the way the Crows have written this because they've referenced every single document and portion of the trials and testimonies that they are referencing here. The continuing false narrative. Mary Ellen Attridge was picking a jury in Treadway's case, which was severed from the others and scheduled to go first, when she got a call from Dr. Ed Blake. Blake was calling about his examination of some physical evidence. Since first entering the case, Attridge had been trying to get access to the physical evidence. Stefan kept dragging her feet. Attridge got her chance when Stefan went on vacation. The 707 took so long, 4 months, that Stefan took a vacation. Court adjourned while she was on vacation. Judge Hams told Attridge that she could make good use of the time by going down to the police station and looking at the evidence. Attridge went to the Escondido Police Department and looked at the evidence while Stefan was on vacation. Attridge saw stains on Tuitt's shirt. She could not tell what they were. Tuitt was a transient, so the shirt had many stains. She did not know if any of them were blood. She decided to find out. She contacted leading forensic Ed Blake, PhD, who, in addition to being an expert in examining trace evidence, was also one of the nation's leading DNA experts. Under California law, the defense has a right to examine and test evidence independently, except when it will completely destroy the evidence. Then other rules apply, which was not the case here. Attridge hired Blake to examine and test the physical evidence. When Stefan returned from vacation, Attridge told Stefan that Attridge was going to seek an order from the court allowing her to have the shirt and other items examined independently by Dr. Blake. This is the context surrounding Stefan's assertions in her sworn application that she agreed to test the shirt. Her agreement was irrelevant. The shirt was going to be tested by Attridge whether Stefan liked it or not. Stefan's statement that she agreed to share costs implies a desire to cooperate and help. It was not. It was a tactical maneuver. By offering to pay half the costs, Stefan turned Attridge's defense expert, who did not have to tell the prosecution anything, into a joint prosecution defense expert. By paying half the cost, Stefan could find out everything Blake knew. Attridge agreed because 1, she knew Blake's findings were going to be his findings regardless of who was paying him, and 2, she could cut her expert witness bill in half. These facts prove that Stefan did not take it upon herself to delve into every piece of evidence. The truth is, she did not examine the shirt, did not ask a qualified forensic expert to examine it, did not retain an expert to examine it for DNA, and resisted efforts by Attridge to obtain access to the physical evidence. The reason this key piece of evidence was looked at, examined, and tested is that Stefan went on vacation, while Attridge diligently did her job. Stefan's inaccurate statements about Blake's findings. In her sworn application, Stefan says, "The results, however, do not determine whether the blood stain was caused by a splatter or, as argued by defence lawyers for the transient, by cross-contamination due to poor lab practice. This is not true. Blake told everyone beyond any doubt that the blood on Stephanie's shirt was spatter. Stefan and the Escondido police resisted this. They wanted the blood to be transferred because if it was splatter, Chewett had to be the killer. Stefan and the Escondido Police Department's desire that the blood be transferred and not spatter gave rise to the tripod theory. The tripod theory went like this. Stephanie was stabbed to death on January 20th between 10 and 12 p.m. Her body was discovered by Grandma Kennedy at 6:30 a.m. on January 21st. Chewett was questioned by Sweeney, who did not bother to ask if he had killed Stephanie because he knew Michael had done it, at the police station. Sweeney took a picture of Chewett wearing the shirt at the police station. Sweeney took Chewett's clothes and put them in a bag. The bag was examined 3 months later, on April 28, when it was photographed by the Escondido Police Department. According to Stefan and the police, this is where the supposed cross-contamination and transfer happened. According to Stefan and the police, the tripod was used to take pictures in Stephanie's room in the week following her death. Somehow, they claimed, the tripod must have picked up Stephanie's blood from the floor. By this time, the blood was hard. Plastic is ordinarily used to protect tripod feet. According to the tripod theory, 3 months later, on April 28th, the same tripod which had been used to take photographs at the Crow House in January was used to take photographs of Chewett's shirt on the 28th. Stefan and the police claimed that on April 28th, Chewett's shirt was sprayed with fluorescein used to make blood glow. Seeing no blood, they photographed the shirt using the tripod. The tripod theory said that Stephanie's blood, which had been deposited and remained on the feet of the tripod since January, 3 months earlier, this is a ridiculous theory anyway, somehow got sprayed with fluorescein, which caused Stephanie's blood to become liquid, which somehow caused it to migrate to Chewett's shirt. There are 2 problems. First, Sweeney took a photograph of Chewett wearing the shirt on January 21st at the police station. A forensic photographic expert positively identified the stain found by Blake in the photograph of Chewett taken by Sweeney on January the 21st. It was identical in size and shape. This proved that the blood stain Blake found was on the shirt on January 21st, not 3 months later, per Stefan and the police department's tripod theory. Second, Blake stated unequivocally that the blood was spatter, not transfer. The DA's office and the Escondido police tried to convince Blake that he was wrong. Blake invited everyone to come up to his laboratory in the Bay Area. He promised to listen to all of their points and respond to them. Attridge Detective Claytor, DA Investigator P.J. Hahn, Woody Clark and others flew to the Bay Area. Clark was a highly experienced, respected DA who was very knowledgeable about DNA. After the meeting, Clark and Attridge basically just listened while others tried to convince Blake that he was wrong. Blake refuted all of their arguments. He concluded by saying, "Gentlemen, it's spatter. Get over it." On the way back to San Diego, Clark apologised to Attridge. "I'm sorry about all of this," he said. "It's obviously spatter. Chewett murdered her. The boys had nothing to do with it." Stefan's response to Blake's findings. Faced with the inevitable, Stefan filed a motion to dismiss. It was a press release masquerading as a legal pleading. It was prepared with the help of the DA's Public Affairs Department. It was 40 pages long. For 36, it recounted, unfairly and incorrectly, all of the evidence against Michael and the boys. On the last 4, it reported the discovery of the blood and Blake's DNA finding. The case was dismissed without prejudice. It's interesting that she could come up with 40 pages of evidence against Michael and not 40 pages of evidence against Chewett, which we just went through in the last video. Stefan's appearance on national television. Stefan went on national television to explain her handling of the case. She sat down for a 2-hour-plus interview with 48 Hours. Sitting nearby was Gail Falkenthal, the DA's PR person. Stefan gave her most compelling piece of evidence speech. The most compelling piece of evidence was that his sister's door was closed at the time and he saw nothing amiss. The investigation showed that it is pretty much not reasonable that somebody could walk out of their room at 4:30 and not see the body there. She knew this was not true. She knew that she had conducted a reconstruction at the crime scene under identical conditions that proved Michael could not have seen anything. She knew she had the photographs to prove it. She knew she had concealed this evidence. She gave her most compelling piece of evidence speech with impunity, secure in the knowledge that her false statements could not be refuted. Stefan knew we, the Crowe family, the victims whom she professed to care about, did not know about this evidence that she had withheld. She knew we did not have the photographs she had taken which proved that she was not telling the truth. She knew something else. She knew that no one else who was at the reconstruction was talking. She knew they'd likely never would, unless something drastic happened. Something drastic happened. We filed a federal civil rights case in federal court. The other side fought us tooth and nail from the District Court, Ninth Circuit and Supreme Court of the United States. We fought them for over 10 years. Our lawyer got all the records and documents and took depositions, well over 100 of them, of people like Claytor, Sweeney and Stefan. Stefan's reliance on Michael's confession in 48 Hours. Stefan repeatedly relied on Michael's confession in her 48 Hours interview. Who did that confession? Oh, that's right, Chris McDonough. By doing so, she shielded herself from liability for libel. Stefan introduced Michael's confession in court. It was not really a confession because he did not admit that he killed Stephanie, which made it part of the court record. Pleadings, documents or other evidence presented in court are shielded by absolute judicial immunity, which means that no one can be sued because of what they say in a pleading or a document filed within the court. In her 48 Hours interview, Stefan skillfully conveyed the idea that Michael murdered Stephanie without directly saying so herself. She did this by referring to his confession. Stefan was asked what motive Michael had for murdering Stephanie. The motive for murdering Stephanie, as laid out by the confession and as corroborated by other evidence, was that Stephanie was such a delightful girl. She was an angel by all counts. She, just to look at her face alive, is to smile. She's the kind of person that brings out everything good and touched people. She was a wonderful little girl. Michael, Stefan said, was jealous of this angel and decided to kill her because he hated her. The motive, as laid out by the confession, it's not my motive that I created. You just go by the evidence that you have. Is that her brother hated her, that he hated the attention she was getting. He hated Stephanie. But that is not all. The motive grew. It was fueled by Dungeons and Dragons. Some of this is so ridiculous, it makes me laugh. And I'm not laughing at the circumstances, I'm just laughing at the ridiculousness of these prosecutors. Stefan explained that Michael and the boys like to play Dungeons and Dragons. Stefan said, I think the Dungeons and Dragons game, just looking through history, there has been several cases, several murder cases, that have been connected with people playing that game. I don't think it's the cause of murder in any way, Stefan said, but I think it shows us a way that minds can come to plan an event. And in these games, it happens to usually be an event to kill or destroy the enemy. They serve to show how someone could pull off this murder undetected. According to Stefan, Michael enlisted his friends in the murder. There's a person that starts the ball rolling, and then you have people who climb onto the ship. The reporter asked, and Stefan answered. Question, but I mean, it is hard to believe that an older brother could hate his little sister, who was, by all counts, this angel-like child, so much that he would recruit his friends, plot out a meticulous killing, carry it out. It's hard to believe. Answer, it's very hard to believe. Perhaps by an average mortal, but not by Stefan. It was easy for her to believe it. She went out in search of an expert to back up her theory. She found him at a shopping mall working in a game store. She called him as an expert witness at the 707 hearing. Now here's where it all gets juicy. Stefan knew the confession was obtained by torture. At the time Stefan made her statements to 48 Hours, she knew, or should have known, that Michael's confession was extracted using psychological torture, which shocked the conscience. If you haven't watched my last video about that particular subject, go back and watch it. The Ninth Circuit reviewed the videotapes and transcripts of Michael's interrogations and said this. Interestingly, the Crowe family have pulled the exact same paragraph out that I did. One need only read the transcript of the boys' interrogations or watch the videotapes to understand how thoroughly the defendant's conduct in this case shocks the conscience. Michael and Aaron, 14 and 15 years old respectively, were isolated and subjected to hours and hours of interrogation in which they were cajoled, threatened, lied to, and relentlessly pressured by teams of police officers. Psychological torture is not an inapt description. The Ninth Circuit held. Further, defendants are not entitled to qualified immunity because it was clearly established at the time of the boys' interrogations that the interrogation techniques defendants chose to use shock the conscience. In her sworn application, Stefan portrays herself as a victim, as well as a heroic figure. She was victimized by media accounts, which related to me the questionable decisions that were made at the outset of the case. She was confronted with an extremely unfair situation of being handed someone else's case months after critical decisions had been made, not the standard practice in murder cases. I followed my conscience and did the right and ethical thing. She was heroic because she did the right and ethical thing. She was guided by an internal compass that did not focus on how things would look, but on doing the right ethical thing. I have provided proof that these factual assertions are false and that the message conveyed is untrue. Betrayal by Bonnie Dumanis. When Bonnie Dumanis decided to run for DA against Paul Finks, her main weapon was the way his office, including Stefan, had mishandled the Stephanie Crowe case. Dumanis called and asked for my help. She said that Finks was a terrible DA and that the Crowe case proved it. She said that Stefan had botched the case so badly that it was likely the real killer would get away with murder. She said that Finks had failed to rein in and properly supervise Stefan. Dumanis said that Michael's confession was sickening and obviously coerced. She said that none of the things the police coerced out of Michael matched the physical evidence. She promised that if she became DA, she would do everything in her power to see that her real killer was brought to justice. She asked if I would give her Stephanie's picture to put on her desk. I did. She asked if I would go on television and do an ad supporting her. I did. At the time, Gimanis told me Pfingst had recused himself in the Crowe case and turned it over to the California Attorney General. The AG had forced the Escondido Police Department to turn over the case to the San Diego County Sheriff's Office. Veteran homicide detective Vic Caloca was assigned to the case. After an extensive investigation, Caloca told the AG that Tuitt was the sole killer and that the boys had nothing to do with it. Caloca's boss, Sheriff Bill Collender, went on TV and said Tuitt was Stephanie's killer and that the boys were completely innocent. The California Attorney General assigned top-flight prosecutors to the case. Dave Druliner, the top trial lawyer in the AG's office with years of experience as a homicide prosecutor in Sacramento, Jim Dutton, a top attorney in the San Diego office of California Attorney General, and Gary Scones, the head of the criminal division of the Attorney General in San Diego. They prepared the case diligently for months. A jury convicted Tuitt of voluntary manslaughter. Gimanis beat Pfingst and became San Diego's new DA. Tuitt appealed his conviction. The Ninth Circuit reversed, holding that the trial judge had improperly curtailed defense counsel's cross-examination of an expert witness about his bias towards a defense expert witness. The case was returned to San Diego for trial. When the case was returned to San Diego, I learned from Caloca that things had taken a change for the worse. Dave Druliner, the experienced lead prosecutor in the first trial, had a serious medical problem and was unable to participate. His second chair, the able Jim Dutton, was retiring, so was Supervisor Gary Scones. There was a new California Attorney General. A new prosecutor with far less experience had been assigned to the case. Caloca felt that unless an experienced homicide prosecutor was assigned, there was a chance the case would be lost. Regardless of who the DA happens to be, for at least half a century, the San Diego District Attorney's Office has had a stable of veteran homicide prosecutors whose experience in some cases is 2 or 3 decades. There was no reason why the case should be taken back to the DA's office. Pfingst turned it over to the AG. Pfingst was no longer the DA. There was no reason why the new DA would not take the case back. I determined that the AG was very willing to turn the case back over to the DA. I asked a person very high up in the DA's office to ask Gimanis to take the case back. She refused. She said there was no political mileage for her in it. I've never disclosed how badly Gimanis betrayed me and my family. Like a lot of things having to do with my daughter's murder, I sucked it up. Stefan's application, together with the story she and Gimanis have been peddling in the press, caused me to come out and tell what really happened. The issue before the Board of Supervisors. The issue before the Board of Supervisors is who should be appointed to serve as interim DA. Stefan wants to be appointed because it will give her a political advantage. She will be able to run as the incumbent. She has already announced her candidacy for the permanent position. Gimanis has endorsed her. With Gimanis' help, Stefan has racked up endorsements. The board has allotted 3 minutes for each prospective interim DA to present their case. 2 of the candidates have promised that, if chosen, they will not run for the office. Stefan has not. The question of whether Stefan is qualified to be DA is something which should be decided in a contest election after citizens have had time to hear from the candidates and consider their qualifications. Stefan should not be chosen. Stefan chose to single out the Stephanie Crow murder case as a shining example of her skill, competence and ethics in her application to the board. By doing so, she made ancient history, the murder of my daughter on January 20th, 1998, breaking news. On May 30th, 2017, Stefan chose to use her handling of my daughter's murder case to advance her political ambitions. She chose my daughter's murder case to prove that she was ethical and competent. I have proved that she is neither. Stefan chose to use my daughter's murder case to portray herself as a victim and cast herself as a hero. I have proved that she is neither. Stefan chose to use my daughter's murder case to congratulate herself for never having been found to have committed prosecutorial misconduct. By claiming this rare achievement, she insulted and demeaned all prosecutors. Stefan's rare thing statement tells us something already shown, her lack of veracity. But it also gives us insight into the inner workings of her mind. Do we really want someone who thinks it is ordinary, common, usual, everyday, the dictionary opposites of rare, for prosecutors to commit misconduct to be running the DA's office? In a recent interview, Paul Pfingst was asked by the Union Tribune to comment on the irony that Giumanis defeated him because of the way his office mishandled the Crow case, and now Giumanis is endorsing the prosecutor who mishandled the case to succeed her. Pfingst replied, "It's politics. I get politics. That's what politicians do." That's the problem. It's time to get politics out of the DA's office. It's time for a DA who is a professional lawyer, not a professional politician. Someone who understands that a prosecutor must be ethical, competent, and committed to assuring that guilt does not escape, nor innocence suffer. Sincerely, Cheryl Crow, Stephen Crow.